relay store in Wellington. This one over to
OG8.
Oh, and it is OG8. Is that what you said? OG8. What's the number on the top? And at the same time, we're going to table, does this have a number?
No, it's just
Table the closing submission from the three agencies. So from Nelson Marlborough Health, the police, and the alcohol licensing inspector. So that is their closing summary. In terms of the proceedings this morning, I think we agreed that Nick, you would go first in terms of your closing summary. Then we would hear from the police. For Alexandra, you are going to speak on behalf of the three agencies. And then Nick, you would have an opportunity to respond to that. Does that sound fair? Yep. Okay, great. So Nick, I'll let you begin.
Thank you, Kate. And look, thank you to reporting agencies for this document. Look, I haven't had an opportunity to read it, so what I propose to do is to deal with that in my reply. Okay. The Nelson store is a travel and retail store. That was where I opened yesterday morning. And what I would say in that respect is that it's very clear in my view that the framers of this legislation, and this is something that I've included at page 71 of my submissions that I'd filed, and this is the comment under section 243, paragraph 243, and this is a comment made by the Social Policy and Justice Group in the departmental report for the Justice and Electoral Committee. They said, while we note the concerns about the lack of guidance, the decision not to include any further detail on what is and is not an appropriate complement to alcohol was deliberately made. There's existing case law around what is an appropriate complement under section 36(2)(b) of the Sale of Liquor Act that can be drawn on, and that's referring to the 1989 Act. Any further attempt to codify this also runs the risk of not being sufficiently flexible to accommodate future changes in the retail environment. And the use of those words, retail environment, in my submission is very much what we're needing to get into the detail of today. So in terms of my closing here, there are really three key parts to this. The first is I just want to reiterate what the committee's role is as the authorities have defined that. And I'll just briefly touch on that. In the second part of my closing, we'll deal with those 5 questions that I'd posed, and that in my submission, that is the only correct legal test for you to apply. And then the third aspect of my closing will get right down into thinking about the role of this committee in assessing as part of determining this application. What is the prospective risk of alcohol-related harm should this premises be granted an off-licence? And thinking about that proposition, what could be done in terms of the object of the Act here to minimise that harm? And my submission to you is there are a whole range of reasonable steps and reasonable conditions that you could consider. And so I'll address those specifically, because when you're thinking about risk, you must think about, in terms of a risk assessment process, what's the likelihood of that risk? And what would be the severity of that risk were that to result? And my thinking is that as the committee, you've got a range of sensible options that you could think about, levers, if you will, that you can pull to help minimise a risk of alcohol-related harm with this application. And my submission is that this is an application that is capable of being granted based on a current application and with the imposition of conditions as the committee would see as appropriate. So the first part of my submission then, that just simply mirrors briefly what I've set out in my written submissions. And this is on page 4, up the top right. I'm following that number, 4 of 72. And this is emphasising the approach that's required of you. I would submit that you are a quasi-judicial body. You must follow the Sale and Supply of Alcohol Act, and you must follow the law and the manner in which you conduct your task of determining this off-licence. And I'll do my level best to provide my submissions to you on what I say the law requires you to do and how you should apply and interpret the law, where there is, as suggested by the reporting agencies, I think it was the words of Carol McIntosh, where she used the word vague, I believe, or fraught with difficulty. My submission is that this is not an area that's fraught with difficulty. There's a straightforward task for you to follow. But critically, you must be satisfied that the licence should be granted. And I've included some comments about what that means. I've indicated that my submission, there's no positive onus of proof here, for example, that you're required to have regard to the criteria in section 105. And in particular, when thinking through your task to the extent that you form an opinion under section 35, that's for you to do, the committee. And my submission is you must have regard to the evidence. You must have regard to what each of the witnesses that have appeared before you have said in their evidence and have answered in cross-examination and in re-examination. That is the evidence that you should have regard to when you form that opinion. So that's really just simply the first part of my submission, seized of your task, approach it, as Kate, you've indicated, with an open mind. So then the second aspect that I will, turn to then, and these are the 5 questions, and I've set those out in a substantial amount of detail in my written submissions there. And what I propose to do is adopt that written framework here before you, and I will speak to them, and I will do my best to apply the evidence that we've heard, which updates these written submissions. These 5 questions have been taken from the decision of the licensing authority in Gladding and Glenorchy, which was the decision we spoke about yesterday. That is where this has come from, and you'll understand that Gladding had dealt with section 34 licence. But it is my submission that the same 5 questions can be adapted for a section 35 licence, and that's why I have adopted that approach. So my submission to you is that that's the approach you must follow. So accordingly, I'll speak to each of those now. Question 1. It's my submission that the applicant's premises are not of a kind set out in section 32(1). And just briefly, because there was some discussion in terms of the various types of off-licences, there are 7 different types of off-licences set out there in section 32. The first is a hotel or tavern, so you can satisfy yourself plainly it's not a hotel or a tavern. The second is for retail premises, which I would say effectively are a bottle store, which is 85% of the annual sales revenue is expected to be earned from the sale of alcohol for consumption somewhere else. So this is not a standalone bottle store. And then section C speaks about if there's no retail premises, but 85% of the annual income is expected to be earned from the remote sale of alcohol. So a remote bottle shop, which primarily is online, in my understanding. The other one is the manufacturer of alcohol. So plainly, it's not that category. The next category speaks about a supermarket with a floor area of at least 1,000 square metres, plainly not a supermarket. And then F speaks about premises that, in the opinion of the licensing authority or committee concerned, are a grocery store. So my submission is that this is not a grocery store. And in my submission additionally, the reason why a grocery store is included there is this Act provides a regime for dealing with businesses where their principal business is the sale of food products. And that's a definition in the Act. And in a grocery store, that's one of the criteria that they need to meet. So it's plain from reading through those categories that this is not a Section 32 premises. So you can answer question 1. It's not a Section 32 premises. Okay. Well, let's move on then to the second question, because this, I think, is going to be a real area of focus for you as a committee. This is the question of Section 36, and I'll just read that for the committee. And this was the no-off licences for petrol stations, certain garages, dairies, convenience stores, conveyances, or shops within shops. That's what the heading says. And it says the licensing authority or licensing committee concerned must not direct that an off licence should be issued for any premises if, in its opinion. So there's your opinion forming exercise in relation to the premises. And if you direct your attention to paragraph C, they are a shop of the kind commonly thought of as a convenience store. And as you know, convenience store is not defined, and the words commonly thought of are not defined. So my submission, this cannot be considered to be a dairy, and that's open for you as the committee to have regard to. I also submit that it's not a convenience store, and I'll explain in some detail why I say you should come to that view. What I've highlighted, and you'll understand that this was a key focus of the questioning yesterday of the reporting agencies, was working to speak to the criteria that are set out in Gladding, and in the particular sections of the Gladding decision. And in my submission, you as a licensing committee are bound to have regard to that because it's a decision of the licensing authority. And I'd focus particularly on paragraph 72 and 73. So when you form your opinion that it is not a store of a kind commonly thought of as a convenience store or dairy, Gladding tells you, in my submission, how to approach your task. So this is page 33 of 72 of my submissions. And the particular paragraphs that I want to look at are 72 and 73. What's that to the correct page? Yeah, page 33. Page. So if you have that there in front of you, this is what the licensing authority is saying. This is not a submission by one of the parties. This is the authority in their own decision. And they're satisfying themselves in relation to the Glenorchy store that it's not a shop of the kind that's commonly thought of as a convenience store. What I would say is that is what you're required to form your opinion about. it is a negative proposition. You need to satisfy and form your opinion that it is not a store, a shop of the kind that's commonly thought of as a convenience store. Now, interestingly, for this criterion, my submission is you do not need to conclusively determine what shop of a kind it is. That's not what the Act is requiring you to form an opinion about. So my intention yesterday, in particular, in cross-examining the sergeant, was about each of these factors. And you'll recall that I paused on doing that after some intervention from the committee. So the focus that I took was having regard to, well, what is the evidence from the applicant? What does the applicant's evidence say about each of these particular factors? And that is what I rely on now in my submission when I direct you to the evidence that you can have regard to in forming your opinion. So when you consider, and as you must, the type of store, labels are not determinative. So the evidence that I say that it is a travel and retail store is not determinative. In the same way that simply because the licensing inspector decides to use the phrase airport convenience store, that is not determinative of whether it is in fact a shop of a kind commonly thought of as a convenience store. And under cross-examination, the inspector was candid in my submission that those were her words. She has chosen those words, but it is your choice of words that you want to characterise the store as. So that in terms of the type of store, that's one of the factors. Its size is a relevant factor. Now, there was discussion in the evidence of 143 square metres. In my submission, that is a large store. In terms of its layout, there's in my submission, a clear definition in terms of the relevant layout of the store. And we looked at the store plan to understand that the far right-hand third of the store is primarily where the store is going to display the products that it says has that local focus. So you need to consider that layout. And in my submission, having regard to the row ends, consider the evidence that Nikki Page gave about those store ends, because she was clear, in my view, about understanding that there is the current format of the store, and that if a license is granted, there will be further investment and changes made to the store, including removing those end rows where there might be some packaged chips or lollies would be moved into the left-hand side of the store. So that my view of her evidence is that can satisfy you as in terms of the layout of the store. Another factor in Gladding that you're drawn, the fact it has its own kitchen. Now, there's no evidence that it has its own kitchen, and plainly the store doesn't. Now, in my encouragement of you to take a view of the store, go and find the kitchen. It's not there. So you can satisfy yourself to that. And thinking about a convenience store, it's highly relevant in my view about a kitchen. Because if you were to think about what I submit, it could be commonly thought of as a convenience store, one right across the road, for example, where is the deep fried food? It's not there. Where are the pies or sausage rolls? They are not there. They're not for sale in this type of premises. Where are the milkshake machines? Where are the scoop ice creams available? None of those are there plainly. And those are highly relevant factors that I would highlight for you. And part of the reason that I look to that is that this Act does set out a defined regime where it excludes certain types of foods from being considered food products that a grocery store might sell. So ready-to-eat prepared foods, for example. Snack foods, and then also convenience foods. So those are not considered food products, and only food products could count toward whether its principal business was a grocery store. But again, we're not talking about a grocery store. We're focused on this, the Nelson store as a Section 35 store. So the other factor that the authority directs you to look at, well, 2/3 of the retail floor space is used to display gifts and souvenirs, with the balance 1/3 being used to display food and household items. Now, my submission is there's nothing in Section 35 that requires you to consider at least 2/3 must be, for example. There's no criteria like that. So you do have a flexibility in how you consider that criteria.
Sorry to interrupt. You said Section 35, but you meant Section 36.
I beg your pardon. Thank you.
Yeah.
Yes, there's nothing in Section 35, for example, Section 36.
We're considering 36 at the moment. Yeah. There's nothing.
Sure.
Yeah.
I'll reframe that. When Gladding is suggesting has had regard to 2/3 of the retail floor spaces for displaying gifts and souvenirs, there's nothing in the Act in Section 36, for example, that states that there must be a 2/3, 1/3 focus, for example.
Yeah.
So that's not determinative in my submission. It speaks about the types of gifts. Now, I think the types of gifts is something that the reporting agencies have substantially overlooked, because thinking about the types of gifts that are sold in the store, we had in the agenda bundle a picture of some of those products that would be sold. And this is thinking about it in the Section 36 lens. So if I look at the application where we have, and this is on page 38, of the agenda bundle. My submission is that those specific products from those producers would not be sold in what I would say is a convenience store. And I think that's highly relevant here. And so the chocolate, for example, from bespoke local producers like Aroha or Hogarth, for example, that would be my submission. And having a consideration of global soap or other botanical New Zealand products, those types of products wouldn't actually be sold in a convenience store. They're high-end products or boutique or bespoke products in my submission. So if you think about those types of products, that's helpful to understand the types of gifts, beauty products. And another category here that you were directed to, jewellery, stationery, honey products and souvenirs on sale. Both Ms. Steer and also Ms. Page spoke to those types of products that would be sold in this store, very much with the vision that this be a local store. So in my submission, I think it's important to focus on those matters as well. Now, considering also what might be in your mind about Section 36, well, the authority speaks to that a little bit further as well. And this is back at page 33. At paragraph 73, this is what the authority has said. While Mrs. Woolies sells food items that you would find in a dairy or convenience store, now that's accepted by the applicant that yes, it does sell Whittaker's chocolate, and it does sell other confectionery, and it does sell chewing gum. But the authority says it sells much more, and that's my submission. That is exactly what is happening in the store and is to occur. So the authority goes on to say it defies common sense to say that only those things in common with a dairy or convenience store can be considered when forming an opinion. So that's your task you do have this broad ability to consider what is sold in the store. But importantly, really critically, the authority goes on to say, nor is the test whether the store is convenient. Because plainly it is on one measure, and Ms. Deere conceded that yes, it might be convenient for a traveller going into the Nelson store if they were going to board a flight to purchase a pair of earphones. But the authority is the authority is clear in my submission that it's saying there's nothing in the Act to support a test of thinking. Is the store convenient to travellers? Now, I'd highlight that from Ms. Odendale and also Ms. Deere highlighted that the inconvenience of having to travel to the Nelson store by locals, the inability to buy milk, the inability to buy bread, those things are just not sold there. So that goes towards, in my submission, being able to conclude, well, it's not a shop of a kind commonly thought of as a convenience store. And one of the aspects that in Gladding that I think is also helpful to highlight here, and this is at page 27 of my submissions bundle. This was what the lawyer for the store submitted to the authority. He says at 32, further, it is submitted that the appellant, and that was an objector who was appealing the issue of the Glenorchy store obtaining an off licence, says the appellant focuses on the literal meaning of the word convenience and finding the premises to be a convenience store. But this is the wrong test and applies the word convenience out of context. It is submitted the test is not whether Mrs. Woolies is a convenience store. So as you'll see from what I've read in 73 of that decision, the authorities accepted that. And there's also another useful point, perhaps, Kate, to what you had inquired about. Well, what is a convenience store? And this is at paragraph 34. So this is what Mr. Cunliffe had said. He said, unlike other convenience stores, Mrs. Woolies is not open 24 hours. And that's the case here. It's not located, is not located in a busy metropolitan or inner city location. And that's also a factor that applies here. This is located at the Nelson Airport. Now, it does not sell cigarettes. Now, it's acknowledged that there is tobacco sold there, and does not focus on takeaway fast foods. And that's my submission, that there's no focus on takeaway fast foods here. So that is a key focus on the section 36, the section 36 factors. What I would say, and then this is returning to my written submissions, and this is again back at page 6. So taking what I say at paragraph 24 here, questions not whether the store is convenient, and the authority's view is that a particular premise must be considered in totality, and in each case it's a matter of judgment and degree, and that is your task. You've got to do that task. So my submission is that this store, as I've indicated, sells much more than convenience foods, for example. It sells gifts and souvenirs and a broad range of travel and retail products. And 55% of its revenue, and my submission, is derived from the sale of products other than the so-called convenience foods. And Ms. Deere's evidence is that the products are often purchased as a gift or memento of a passenger's visit to this region or where they've not had time to visit directly. again, what Ms. Odendale said, the gateway to the region. Don't overlook the purpose and vision of this store to support this region and its local producers. That is what is being sought. So the last comment that I wanted to make is just to help you understand as a committee about what types of stores and why I've drawn this night and day comparison, for example. And that was in the decision that I refer to there at paragraph 26, which is in Tricorp Holdings Limited. This was a particular night and day store, and that was held as a convenience store. And some additional factors that the authority had highlighted was limited fresh vegetables. There's no fresh vegetables sold in the Nelson store. Confectionery described as looming large in that decision. A small range of products from which meals could be prepared. Well, the Nelson store doesn't contend that it is selling food products or providing products from which meals could be prepared. Large frozen self-serve ice cream machines, again, those are not here in the Nelson store. The absence of trolleys. My understanding is there's not even baskets in the store, but have a look at those factors when you're in the store. So those, the authorities held, are indicative of a convenience store rather than a grocery store. That's where I get to in terms of thinking about you forming an opinion, and it's of a shop of a kind commonly thought of as a convenience store. The sergeant was clear in her answer to me under cross-examination. She hadn't sought anyone's views or opinion about that matter. And my submission is there's no evidence from any of the reporting agencies about views in this community. And by contrast, I would highlight and emphasise the support that the store has obtained from the likes of the Nelson Tasman Chamber of Commerce and its opportunity to assist local producers in conveying products that wouldn't be sold in a convenience store. I'd say that's representative of a view that this could not be commonly thought of as a convenience store, but ultimately that's going to be a matter for your opinion. In that respect, I say to you, follow the evidence, listen carefully to the cross-examination and form your opinion. And plainly in my submission, it's not commonly thought of as a convenience store. So that would be the second question for you. The third question then I pose in my submission here is, are the premises a shop where the principal business carried on is not the sale of food? This is section 35(1)(a). Now, there's been a detailed amount of question asking and answering about this section. I'm not proposing to labour this point for you because in my submission, this is not a complex task for you to undertake. The task for you set out in section 35 here is that you be satisfied. You don't need to form an opinion here. You need to be satisfied. So you need to consider that previous comment from the Court of Appeal in Queen and Leach that I've referred to. It means simply make up your mind. It's indicative of a state where you, the decision maker, on the evidence comes to a judicial decision. So you still have to look at the evidence that is before you. But the key aspect that came out of the cross-examination yesterday that I'd submit to you is that the approach of the reporting agencies to considering this question is not informed by any analysis. It's not informed by any reasoning. It's not informed by any guidelines. It's not informed by any opinion. And that's not intended as a criticism of the agencies. They've simply identified that they've turned, looking at 35(1)(a), they've looked at the definition of principal business, they've turned to the regulations, they've been stopped in their tracks by subheading, and then they've just moved away to an area that is plainly has no real justification. That's my submission. So this is a path for you to choose. And you can either, as I say, follow the Sale and Supply of Alcohol Act, or for some unknown reason, you can follow the Food Act. Now, if you do that in my submission, you will fall into an error of law. It will be wrong for you to do that in my submission. The reason why I say follow the Act and the regulations is because actually the regulations provide you with a really good framework, a sensible framework. And when you look at Regulation 6, in my view, there's a reason why the framers of the legislation have used the words principal business, have used the word premises rather than grocery store. And there's a reason why there are separate regulations that require statements of annual revenue for grocery stores, and that's Regulations 12 and 13. So Regulation 6 can and does, in my submission, apply to the store. And what it does then is it requires you to do a categorisation. It doesn't require you to think, what's the dictionary definition of principal? And the reason I say that is because it uses the term defined in the Act of principal business. So my invitation is use that definition. And then when you're thinking about the test that you need to satisfy yourself of, you need to satisfy that principal business is not the sale of food. And on the evidence in my submission that I've set out in quite some detail there, you're able to arrive at that really simply based on the evidence from the applicant, and in particular the appendix that's set out in relation to Ms. Steer's evidence. And she's given you, under that final category, other sources of revenue. She's given you a detailed breakdown, and she's done that by reference to the store's electronic point of sale system. So my submission, those are accurate figures that allow you to be satisfied that the principal business of the store is not the sale of food, however you choose to define it. There is no mention in the Act of applying a first-in-rank process. And turning to, I know a question that you posed at one point, Laurie, around, well, isn't it appropriate to use dictionary definitions when you're interpreting matters? And I deal with that when I focus on the Legislation Act 2019, and there's a particular section 10.1, which talks about that the meaning of an enactment must be ascertained from its text. So I'd say from looking at the definition of principal business, looking at Section 35, looking at the regulations, and in the light of its purpose. And Section 3 of the Sale and Supply of Alcohol Act doesn't get much airtime in these forums, in my experience, but it is there for a reason, and framers of every legislation will include in light of its purpose. And so the purpose of this Act is in two parts. If you look at Section 3, it speaks of the first subsection is it's reformed the 1989 Act. It's a new system of control. And it reforms more generally the law relating to the sale, supply and consumption of alcohol. So that's the first thing that it says is its purpose. So it's an overhaul. Then the second part speaks about the characteristics of the new system. It's reasonable, and its administration helps to achieve the object of the Act. So it cross-references to the object of the Act. And what I would say is when you're thinking about Section 10.1, within thinking about, well, how do I get to determining that the principal business of this store is not the sale of food? You're stepping back, thinking about the text in light of its purpose. You want to achieve a reasonable system, so one that's not draconian, and in my submission, but one that's its administration achieves the object of the Act. So in terms of thinking about what's reasonable, I would say you should be looking clearly at what the object of the Act is trying to prevent. alcohol-related harm, and then minimising that. And I know that the High Court has spoken about that, and that's minimising to effectively to the greatest extent or degree. I say that it's preferable to use defined terms in legislation, including principal business, rather than just going to the dictionary to use one of those words, principal, when it's used by the framers of this legislation. So look, I'm not going to deal with that and labour it even further, but food, any way that you consider this business just cannot be the principal business in my submission. On the numbers, for example, the maximum number you could ascribe to even thinking about a Food Act consideration, which I say is wrong, but even if you were to do that, run the numbers. It's about $171,000 maximum. And then you need to have regard to the total turnover figure. So you cannot get there in terms of principle in my submission in the way that regulation works. So it's my submission that test 35(1)A effectively can be met. And then there's an and in the legislation. So you need to do A and B. So I've put that as question 4. A and B. So let's look at 35(1)B. So in terms of my submissions, I'm through now to page 11. So this is asking the question, as I frame it, of would alcohol be an appropriate complement to goods of the kind sold at the shop? And the specific wording in the legislation, alcohol would be an appropriate complement to goods of the kind sold or to be sold in the shop, to be really clear. So you need to satisfy yourself of this limb as well as satisfying yourself the principal business is not the sale of food. I wanted to make, I guess, 3 comments about this, and they're not written in my submission here, but right at the gateway, given what we've heard during this hearing. So section 35(1)B doesn't require that the principal business is the sale of gifts, for example, or the sale of beauty products. It doesn't require those things. It specifically talks about this phrase, appropriate complement. And that's not defined, and I absolutely acknowledge that, but I'll speak a little bit further to that. Before I do that, I just also wanted to highlight these other 2 points. It doesn't say that it must be an appropriate complement to each and every single one of the goods sold in that store. And then the last point that I wanted to make was that the sale of alcohol, it doesn't say the sale of wine, it doesn't say the sale of beer, for example. It says alcohol. So that's what this limited exception is enabling, not just types of alcohol. As you know, for a grocery store, it can only sell wine, beer, and cider. It can't sell spirits, but there's no such restriction here on you. So then let's step back. What do I say an appropriate complement is in my submission? Well, I've set out there 2 cases from under the 1989 Act. And plainly, it's not defined. What Justice Tompkins in Wine and Spirits Merchants directs to you, effectively, you need to decide each case having regard to its own facts. So in my submission, that gives you a really good platform to inquire into the types of goods that are sold and are to be sold at the Nelson store when you consider what an appropriate complement is. There's also a decision that I refer to there about application by Lloyd, which described that provision was controversial. What the authority indicates there, however, is saying that, well, a business that sells retail confectionery trading as sweet treats was not an appropriate complement. Now, the business that you have here in the Nelson store is much broader than that in my submission, so it's not restricted or prohibited. I've also referred you to GM Office Supplies, a retail stationery shop selling office products that the authority decided, well, that's not complementary, an appropriate complement. But you do have a broader approach available to you. And when I say the analysis here, I had that discussion with the inspector, was that this store is nothing like the warehouse. So I say you can just put that to one side. So my suggestion to you is think about this. When you think about, and when you go to the store, thinking about that third of the store and what it sells, and whether a small display of unrefrigerated alcohol would be an appropriate complement. And this is having regard to where these products come from, this local focus that is very much in this store in my submission. Think about it in that context, an appropriate complement. And then obviously we'll also talk about these controls in regard to the potential risks that have been able to, and I'll get to that after I deal with this last question. But that's my question for appropriate complement. It is up to you. It is up to you to be satisfied that alcohol would be an appropriate complement to goods of the kind sold in that shop. And again, not each and every single good, but an appropriate complement. So question 5 that I move on to then is, let's step back and let's do also the section 105 criteria that you must have regard to. And this is ought the licence be issued. So if we've satisfied ourselves that it's eligible, then is it desirable? Ought it be issued? And my suggestion is that this is where the prospective risk of alcohol-related harm comes in. So if we think about the various criteria in the Act, I'll just focus on some of them for you. The first is the object of the Act, and I come back to that last because the High Court refers to that as this cross-check provision. So if you think about suitability then, who is the licensee? Well, it's LS Travel Retail New Zealand Limited, and you've had Anne Steer speak on behalf, and you've had Nikki Page speak on its behalf, both senior managers within the business. Nikki in particular, the New Zealand operations manager, spoke of her detailed in my submission oversight and monitoring of that business, the depth of experience within the business of the premises that it operates not only in New Zealand, which hold licenses, but similar types of businesses selling alcohol like duty-free stores. But my submission is that there's no issue with the suitability of this licensee to hold a complementary off-licence. And I'd refer you to Nikki's evidence that she gave in detail about the systems that would be in place at the store. And I took it in my cross-examination of the inspector that she was also satisfied specifically around the system staff and training, and she didn't focus in cross-examination on issues of suitability other than to confirm some general matters that, yes, one of the directors has visited the Nelson store, for example. There's that monitoring process. So that's my submission, is that there's no issue as to suitability. It's not raised by any of the other reporting agencies. Thinking about the days and hours of trading, for example, the applicant is seeking a licence from 7 a.m. to 8 p.m. And in my submission, it was clear from the evidence from Nikki Page in particular that an airport store like this operates largely to satisfy the airport and its airline scheduling requirements. So having a shorter hours of operation of the licence is not something that the applicant prefers. It would prefer it till 8 p.m. And look, I'll deal with some of the other aspects when I talk again about that risk assessment process shortly. Thinking about, for example, amenity and good order. Well, my submission is that the amenity and good order is not raised as an issue, was not a ground of objection by any of the reporting agencies. Sergeant Gibson confirmed the airport's not a hotspot. It's also been confirmed as a high security controlled environment at the airport, and that police attending would only be for airplane or aircraft related emergencies to her knowledge. So in terms of amenity and good order of this business, those concerns, there's no suggestion that's going to be minimised. So thinking about then, I guess, the systems, staff and training, the inspector's satisfied that there will be a number of duty managers there at the premises to be able to conduct themselves. And that's often a factor that is overlooked. The duty manager, when they're on duty in this act, is responsible for ensuring that the licence is complied with. And that's to do all of those practical matters, ID checks, point of sales verification, ensuring persons aren't intoxicated in the store, those other host responsibility factors. That is the person who's responsible to do that. And this applicant is saying to you, we will have those people there at the point of sale able to do that for you and present in the store, which is remarkable in my submission. Then lastly, I guess, and this translates over into that risk assessment phase. It is about thinking about the object of the Act. Now, there are a number of critical factors, and this is why I have said to you that this is actually a low-risk specialist premises. That is my submission of what this store is. And I've spoken about that. That's what the framers of the legislation commented on what the purpose of this provision is. And where I am here, this is at page 14, I just wanted to highlight some of those aspects from Nikki's evidence for you. The focus of alcoholic products is limited. Now, in questions from you, Derek, there was a helpful exchange I took away, especially around the parochialism of our region. That doesn't include Marlborough. Now, I'd submit to you that this applicant's very open to a geographic restriction on producers from the Nelson Tasman region. Very open to that if that was a condition, and that was indeed a condition that was imposed in Gladding, for example. The pricing of the products is actually relevant, and there was some discussion and cross-examination with the medical officer around gift packs, and that was cross-examination with Ms. Steer, that, for example, gift boxes of gin that contain 3 200ml bottles in a gift pack that Ms. Steer said was sealed and wrapped. And the pricing of those products is very high in my submission. They are not capable of ready consumption, and the pricing would deter that. Her evidence was that it's always higher than the producer's cellar door or online RRP or bottle shops. But the focus of taking that away from this area and giving someone a gift is the focus. The focus on the limited range and the actual available store area for alcohol is very limited in my submission. The alcohol is not going to be chilled, so a ready-to-drink format in my submission is not available. And the products are going to be there located towards the back of the store. Now, the applicant's open to locating them in a designated area. So that's one of these aspects that I'll talk to shortly. Even though that's not a requirement of the legislation when you're dealing with the Section 35, it's my submission that this is a responsible licensee who's trying to minimise the risk of any alcohol-related harm around that. So that is what I wanted to speak about now briefly with you. This is the third part of my presentation, and I'm conscious to try and keep to time, noting that this is now 12 o'clock. But rest assured, this will be my final section. Step back, cross-check object of the Act. Could that ever be complied with this application? And my point is simply, absolutely yes, it could. So let's think about the two prospective risks of alcohol-related harm that I say. Now, I will put it to you that I have not been difficult in the way that I have raised issues with what the reporting agencies have zeroed in on. Their objections have all been focused on Section 35. They have not focused on the object of the Act at all in any of their submissions. So up until this hearing, effectively, these are unknown quantities to the applicant. But the applicant does not begrudge that. They are here with you wanting to be constructive about thinking about how this could work. And in my submission, that has not been the focus of the agencies because they've approached 3 brick walls and then they've stopped. But working through that in my submission, there are 2 key risks that have been identified, and they're each capable of resolution. The first is thinking about what's the risk of alcohol-related harm and how can it be minimised in relation to the exposure of alcohol to minors. Now, this licensee has already said located at the back of the store, CCTV cameras, mirrors, small area that it's going to be located in, gift boxes. There's been no evidence as to advertising, for example, of these products outside the store or intended to entice. They've made it clear that they would re-merchandise the store to make sure that any products far down the other left hand of the store that children might be interested in. So how could that risk of harm? But what you also in my submission think through is that what are the other controls inbuilt in the Act at the point of sale to restrict alcohol being sold to minors? They are all there. They are all there in terms of thinking about restricting any minor from selling alcohol. And so there are appropriate controls available. Now, I know the other aspect that was of note to the committee was tastings. Now, my instructions from the licensee is they would agree to a condition that there would be no tastings at the store. Now, there's no obligation on the licensee to volunteer that up, but they're conscious of what's been raised during the course of the hearing and want to think about ways to mitigate that risk and to minimise that risk. So in terms of then the second key risk that I've heard identify as well, what about items that are taken from the store and are consumed in the airport or its immediate environs? And in my submission as well, including for those other factors that I've identified, the pricing of the alcohol, the fact that it's warm, the fact that gift products are wrapped and sealed, for example, making it difficult to consume. But the airport is clear that it has its own security. There'll be signage informing persons that they cannot consume alcohol in the airport. There's also other licensed premises immediately adjacent where persons who do want to go and access alcohol, a drink, can go and purchase that for a much lower price. So that is there at the Wayfarers Cafe, and in better times, the McCashin's Bar, if or when it reopens. So thinking about those risks in a tightly security controlled environment, those risks are already low. And so these are these steps that are taken to deter persons from doing that in my submission. And so if there are other controls or conditions that the committee considers, well, Ms. Page and Ms. Steer have been open to those suggestions. That was exactly Nikki's view about that. So we haven't heard, for example, during the course of the application, ways to minimise this. We did have a suggestion from the inspector about really a shop within a shop, but in my submission that runs up against another problem in the Act that's under Section 36. So practically it's just not a possible solution to it. So stepping back and doing that cross-check in my submission, this is a low-risk specialist premises for you. It's not a convenience store. The focus of the store and the vision for the store is contributing to the local Nelson Tasman region. That is what they're wanting to do for the Nelson Tasman region, and to sell products that complement the best of our region. That is the case for the applicant in that respect. And in my submission then, granting this exception, framers of the legislation allowed you to do this. You just need to carefully navigate your way through those steps. It is not in any way near impossible. In fact, it's practical and it's simple for you to do that, having regard to the evidence in this case. And in my submission, this Section 35 licence can and should be issued. So those were the three parts of my submission that I've worked my way through, and more than happy to address any particular concerns, queries, questions that you may have. But thank you for listening.
Thank you so much. Microphone back on. Thank you so much, Nick. Do we have any final questions, Laurie or Derek? No, I have just two. Actually, three small questions just to clarify, because they came up yesterday. One was around branded apparel.
Yes.
Would the applicant be open to not having any alcohol branded apparel?
Look, I'd have to take instructions. I couldn't, without those instructions, I wouldn't expect that would be a big difficulty.
The other one was, it was mentioned that alcohol would be sold for around $70 a unit. And when I looked at the items advertised on page 40 and 41, whilst these might be boutique to the rest of the country, they're actually fairly mainstream to Nelson region. And I was struggling to see how the per unit price for any of those would be up at that $70 price range, particularly the beer and cider, but a lot of the wines are probably more in your $30 price range. So I'm seeking some clarification as to where that $70
Yes.
came from.
And I can look back in my notes, for example, in terms of that, Kate, and Joe, perhaps if you could just have a look at your notes too. I seem to recall that came up in cross-examination or discussion with Nikki Page, and perhaps that was in reference to a particular product that she was referring to. And I seem to recall there was a discussion about $70 to $100 in relation to a particular product, rather than, for example, in relation to all products, like as a minimum pricing. And so, look, I'll just do my best to try and find that for you, Kate. But what I would say, though, is don't overlook the evidence from Anne Steer that I'd referred to in my closing about the general pricing practices of this applicant, and the way that they would look. So Anne's evidence, for example, was speaking about the pricing of products is always higher than the producer's cellar door or online RRP or bottle shops. So it may have been that actually Nikki was referring only to a particular product. There was I'm just trying to find that. The record that I had, here we are, Kate, was that you asked a question, does the airport have a role as to consumption? I think the answer was something like correct, and a response to enforcement, these are only my notes here, the airport do already, for example, wayfarers have signs. We would have a new information stall that was to be located outside the store. And then Nikki went on to say that the airlines have a strict no intoxication policy. And in addition, our price point would be $70 to $100 and not a bottle that you would want to waste. So Nikki's evidence, I don't think was specifically in relation to a particular product. I'd taken that to mean in relation to wines, for example. But look, I could be.
Yeah, and I guess that's why I'm asking the question, because I don't think Nelson wines are in that price bracket. And so I guess then in terms of what is a fair price for the Nelson store in terms of, I guess, our reputation as a city, I would think that if you had a double markup, then that would be also seen as an unfair, as not necessarily promoting Nelson region in terms of I guess having the monopoly of the airport site. So I am flagging that I'm a little concerned by that it seemed like that was the bottom price. My next question was around spirits. We haven't talked a lot about spirits. And
before we get to that, Kate, could I respond to your comment? Because around the pricing of wines, for example, what I would say though is, and I hear what you're saying from a commercial perspective, from a risk perspective, what the contention for the applicant is saying, if the risk is that people are going to whack open a bottle of wine, excuse the colloquialism, and then consume
drunk it at the airport. That's how the
outside.
Yeah.
Our client is saying there are a number of controls to prevent that, including that there's no pricing around this that would encourage, and that's one of the things that's often overlooked when we speak about the object of the Act, is that there is also some additional language about harm, and it speaks about that the sale of, supply and consumption of alcohol should be undertaken safely and responsibly, and that the harm caused by the excessive or inappropriate consumption of alcohol should be minimised. And so what the applicant is saying to you is, our pricing deters anyone from wanting to quickly drink that product. They are focused on taking that somewhere else to be consumed, to share with friends or family at a dinner, or to provide as a meaningful gift of the region. And so probably the only other thing that I would say is that I wouldn't say that it would be open, for example, for the committee to impose controls around pricing. It's not part of this Act. There was a thinking that there might be some regulations to deal with that, which have never transpired. So I definitely...
I'm not proposing that.
Okay.
I'm not proposing that. I'm just somewhat surprised that that $70 is the minimum price point per unit when I look at the items there.
Yes.
So that's I just was checking. I guess I don't know what the prices for the spirits are, but I personally feel like these whilst there's a boutique to Nelson, they are more mainstream in Nelson than perhaps we appreciate.
May I ask a clarifying question?
I think you can, and you'll summarise, and when you summarise, you can pick that up. So then my last question was around the spirits. I understand under section 35, you can sell spirits, but I'm just clarifying in terms of harm minimisation, would the applicant be open to considering just beer, wine and cider?
No.
So it's okay, that's helpful.
And I'm happy to speak to that if you like. The key reason I think that this Act deals with and using the word alcohol is because there's a deliberate distinction between premises whose focus is the sale of food products like grocery stores and supermarkets who can only sell wine, beer and cider, versus standalone bottle stores, for example. But then this limited exception principle, from the applicant's perspective, they are wanting to purvey the best of the region. And I would say to you, there's no evidence whatsoever in this case that would indicate that there should be a restriction on the particular types of alcohol that are sold. There's no risk that's been identified anywhere in the evidence that spirits, for example, would create an additional or increased risk.
Would you argue then that spirits complement the other items sold in the shop in the same way that wine and beer and cider do?
Yes, specifically because of the focus of the store being local products and particular local distilleries that will be marketing from this region.
Nelson is known as a beer, cider and wine region. It's not known as a spirits region.
Well, I'm just trying to understand, Caitlin, what is the purpose of a restriction around that particular wine, beer, cider, spirits, etc.
In my mind, we heard evidence yesterday that the Blenheim store sells Marlborough wines. It promotes its Marlborough wines. Marlborough is known to be a wine growing region. It's not known to be a wine, cider and beer region. Nelson Tasman is known to be a cider. Apples is a big part of our brand. Hops has become a big part of our brand, and wine is a big part of our brand. I'm not aware of any branding around spirits in this region. So that's the bit, and you've tried to argue a case that the reason why alcohol should be for sale in this store is because it complements other Nelson branded gifts.
Yes.
And whether that be chocolate or honey or souvenirs. I'm struggling to see how spirits is part of the Nelson brand. Even the NRDA's branding is around art and artisans. Yes, I can kind of, but the branding of the region, we're not. I can get that Dunedin is known for its distilleries. It has a Scottish whiskey, and so there might be a branding of Dunedin in terms of spirits. I'm not aware that we promote our region in terms of being a spirit region. And there's the added risk in terms of small bottles of 200ml bottles of spirits being sold. Because
yes,
there is that risk that a 200ml bottle of spirits might be consumed in the bathroom or something. So there's a greater risk in terms of the consumption of spirits.
What I would say, I guess, is to focus on the wording in section 35,
yep,
where it uses alcohol rather than just wine, beer,
yep,
or cider. But at page 39, there was the reference to Dancing Sands Distillery, I understand, and Kiwi Spirit Distillery, which are, to my mind, or my understanding is that they are local Nelson Tasman producers. And I guess if the risk that you are identifying is around consumption of alcohol in the bathrooms, the two things I would say about that, well, there is in fact no evidence of that having occurred, or that it is likely that will occur. There's no evidence for you to form that view, my submission. But the second point more is then,
it was raised by Alexandra as a concern in terms of the smaller volume quantities. So in terms of double shots being, that if it was part of a gift basket. So it has been raised as a concern in terms of...
I've also heard the response from Anne about that in terms of those gift boxes being packaged and sealed to deter that immediate or individual type consumption, and also in the context of other premises for ready consumption and on license, literally steps away. So I wouldn't identify that is an appreciable risk that would need to be imposed to control as in a restriction on spirits. That wouldn't be proportionate response to that risk, which I say there's no evidence of that or likelihood that could occur. So the focus is, though, in thinking about the condition that this licensee would accept, which is, well, let's restrict it to Nelson Tasman. If your concern is that someone is going to consume gin in the toilets, I say that, again, that's not reasonable or likely, but because, to your same point, there are not many local producers of spirits, think about the volume that might be sold from the store in consideration of the pricing, and that actually the risk of alcohol-related harm from the sale of those products is already being minimised in my submission.
Okay, thank you. Yeah, okay. I guess I'm just thinking about gifts. I can get to a place where I have a gift in my head of a bottle of wine or a 6-pack of cider or a 6-pack of beer with chocolates and things. I'm struggling to see how a gift could include spirits. But that's perhaps society changing. I don't know, but I'm struggling to see how someone would come to a dinner party with some araha chocolates and spirits versus some araha chocolates and a bottle of white wine. To me, you've tried to sell an argument that alcohol complements the other items for sale in this store, and I'm trying to keep an open mind of how alcohol can complement the other items in the store, but I do think that certain types of alcohol are more complementary than other types.
And look, respectfully, that is your decision. Yeah. That is for the committee to do. And I would just urge you, be very focused on the evidence that you have before you when you're either forming your opinion or you're being satisfied, as opposed to just what you might think on a personal basis. Mm-hmm. That would be wrong. That you need to have regard to what's been given in evidence in the forum. Mm-hmm. In my submission.
Okay, thank you so much, Nick. Alexandra.
Kia ora. Thank you. I'll be presenting this submission on behalf of the 3 reporting agencies. For applications to be eligible for an off-licence, a premises must positively meet one of the criteria in sections 32, 34 and 35 and not be prohibited under section 36 of the Sale and Supply of Alcohol Act 2012. You will hear from me on behalf of the reporting agencies that this application was addressed under the section that it was applied for, section 35, and it was shown to be non-compliant under that section. Due to the nature of goods within the store, it should also be prohibited under section 36 of the Act. It is therefore not eligible for an off-licence. Section 32 of the Act is titled Restrictions on Issue of Off-Licence. This part of the Act restricts rather than widens the ability to hold an off-licence. The committee must consider that widening the ability to hold a licence may lead to the proliferation of off-licence sales in premises not intended under the Act. This widening of availability of alcohol, resulting in increased access to alcohol and normalisation of alcohol consumption, increases the potential for alcohol-related harm, which is contrary to the object of the Act. It is not the remit of the committee to bend the Act to fit the model that is being applied for. If a licence is issued, this would be the only store of its kind to be granted an off-licence in a domestic airport terminal in New Zealand. We've heard from counsel for the applicant that what is being sought is a shop to promote this region. We heard that the applicant's vision for the Nelson store is heavily focused on promoting smaller local producers. To be clear, there is nowhere in the Act which states that promoting local is a requirement or even a consideration in obtaining an alcohol licence. To be clear, there is nowhere in the Act that the promotion of small business is an objective of the Act. Local products, as we have heard from a witness for the applicant from the Nelson Chamber of Commerce, could easily be promoted within another model. For example, a standalone gift and souvenir store. In fact, there is nothing stopping the applicant from currently expanding their offering of local products, excluding alcohol without a licence, and from undertaking any rebranding activities that would further promote the Nelson region. We have heard in evidence from Nicola Lee Page, the Operations Manager New Zealand for LaGuardia, that LS Travel Retail New Zealand is part of the global travel retail LaGuardia Travel and headquartered in Paris. The company was established in 1852 and has operated in New Zealand since 2011, and they operate retail stores, we have heard, in 10 airports, primarily across duty-free, travel essentials, specialty and food service channels. The directors for LS Travel are responsible for 25 liquor licenses that cover 37 premises across New Zealand and Australia, including 5 airport stores operating in international airside locations that are not required to be licensed. Of these, we have heard 4 premises in New Zealand currently hold a liquor license and include 2 on-premise licenses in Christchurch Domestic Airport, 1 off-premise license at Dunedin Domestic Airport, 1 off-premise license for online sales operated from Christchurch Airport and servicing the whole of New Zealand. The concept that has been described for the Nelson store would demonstrably differ from Lagardia's usual operations, and to the best of the reporting agency's knowledge, be the first of its kind in the country. We heard from Nicola Page that the ambition of Lagardère is that they have this model available in other regional airports. And we heard from Anne Steer that she reported that this model may be expanded into other regional airports in response to what landlords request in each region. Granting of this off-licence to the Nelson store could lead to a proliferation of off-licence premises and the associated increased availability of alcohol. This would potentially open the door to other stores like Whitcoulls or Paper Plus to apply for a licence with exceptions, and other regional airports to open similar hybrid books, news and convenience stores with an off-licence components. Are these models of off-licence what we want in our community? Collectively, the agencies say not at all. We heard from the licensing inspector in seeking clarification with the agent who completed the application for LS Travel that LS Travel clearly understands that the Nelson store differed in the range of products from those which were offered in the off-licence premises operating at the Dunedin Domestic Airport. According to the photos submitted of the Dunedin store and the testimony we have heard from the applicant, this premise operates as a gift and souvenir store. Clearly, the Nelson store significantly differs from the Dunedin store in that it is the sole retail outlet in the Nelson Domestic Airport, catering for travellers, staff and visitors. The Nelson store has been described as offering travel essentials with gifting and souvenirs by the applicant. The agencies note that gifting and souvenirs are the secondary offering in this description and are demonstrably lesser based on sales figures submitted from this application, constituting a generous maximum of 17.5% based on the categories of gifts, souvenirs, apparel, health, beauty, and gourmet foods. As per the applicant's testimony, these categories also cross over with travel essentials, for example, health and beauty, containing both the products that you may need to purchase at the airport because you've forgotten a toothbrush or some Panadol, alongside more specialised boutique offerings from the region. Thus, this total will likely be significantly less. It's important to note that in correspondence with the licensing inspector, the applicant was offered a potential pathway forward to be compliant under the Act by establishing a separate gift and souvenir store within the existing footprint of the Nelson store. This would have had to have a separate point of sales, separate staffing, a dividing wall and a separate entrance to make sure that it satisfied the conditions of being a separate independent store. The agent reported that she consulted with the applicant on the question of whether they wished to amend their application to align with this, and the notion was rejected by the applicant. This proposal, had it progressed, would be similar in offering to their Dunedin store, which has been successful in obtaining an off-licence, where alcohol is available in a standalone gift store and the convenience items are available in a nearby store, which is also operated by the applicant. In continuing with the application to have the Nelson store considered under Section 35 of the Act, essentially the applicant is proposing that the relay store type offering from Lagardère and a gift and off licence are combined in the Nelson store terminal to be known as the Nelson store. I also wanted to comment here on the price point of alcohol that was raised in the questioning of the counsel for the applicant. I would note that many of the probably most well-known regional wines in Nelson would be the Nelson Sauvignon Blanc, which would typically retail for under $20 a bottle. So to convincingly achieve the price point of $70 to $100 that the applicant is noting, this would require a 300% markup to achieve this price point. I would suggest that the applicant will not be able to achieve this for commercial reasons, as nobody would purchase a bottle of wine at this price point, suggesting that these variety of wines will likely be available at a lower price point, once again increasing accessibility and availability of alcohol within the context of the airport. I will now move on to the kinds of premises that can be issued an off-licence. Clearly, the applicant and the agencies are agreed that the applicant does not meet criteria outlined in section 32, and we've heard that from the council for the applicant. The application is made under section 35, the criteria for which is overridden by section 36, no off licenses for petrol stations, certain garages, dairies, convenience stores, conveyances, or shops within shops. We've addressed extensively the principal business. As we noted, the application has been made under section 35 of the Act. Section 35(1) states that the licensing authority or licensing committee concerned may direct that an off-licence should be issued for premises not of a kind described in section 32, if it is satisfied, firstly, that the premises are a shop, but not a shop where the principal business carried on is the sale of food, whether food of a particular kind or kinds or a range of food. And secondly, that alcohol would be a appropriate complement to goods of the kind sold or to be sold within the shop. The need to be satisfied calls for an exercise of judgment by the committee to decide if this is the type of premises that the Act intended to qualify for an off-licence. It has become apparent over the course of the hearing that the sales figures, and indeed the inventory comprising each category of sales, is disputed. It is apparent that without an agreed methodology and a transparent and full audit of inventory and sales, it is not possible either for the applicant nor for the reporting agencies to determine the principal business. Such an audit has not been provided with the application, which relies on gross sales revenues by categories. The applicant themselves has stated that within each category under the sales revenue is a mix of items which comprises both some gift items and some convenient travel items as well. It is clear, however, overall to the reporting agencies that a significant and large proportion of the business operating as the Nelson store is what would commonly be understood as food for human consumption. This comprises at least 27.5% based on confectionery and beverages, and is likely to be higher than this as many of the gourmet food offerings that also are included under gourmet food and gifts may be included in this category. The counsel for the applicant has suggested that an appropriate method for satisfying section 35(1)(a) is for the committee to refer to the Act and the associated regulation, particularly Part 1, Section 6, matters relating to grocery stores. This regulation, we contend, is not suitable for use outside the settings of grocery stores. Using this method, food is separated into the sale of food products and convenience foods with the purpose of determining the relative proportion of each to determine if it is a grocery store or a convenience store based on what is dominant. The counsel for the applicant has just told you that clearly he submits the Nelson store is not a grocery store. If the method were applied to the Nelson store, the types of foods available we would see are primarily of a convenience nature. In a setting that is operating primarily to sell convenience foods, e.g. a relay type store at the airport, this methodology is flawed, as there has been no intent to operate as a grocery store or to sell foods that are not ready to eat. We turn now to section 35(1)(b), complementary goods. In evidence, the applicant agreed that two categories in their sales figures that are appropriate complementary goods are gifts and souvenirs and gourmet foods. They also suggested that some specified items within the other categories could be included in gifting. This included specified items from apparel and health and beauty aids, for example. Problematically, an example that was given was apparel that was branded with brewery or other alcohol logos or messages. This, of course, raises its own set of concerns about alcohol advertising, particularly to vulnerable minors within the context of the airport. The percentage sales figures comprising the agreed categories of complementary items, i.e. gifts and souvenirs and gourmet foods, comprise only 7.2% of their total sales. What we can assert from this is that when considering the Nelson store as a whole, alcohol would not be an appropriate complement to the general goods of the kind sold in the shop. Therefore, section 35(1)(b) is not met. The majority of the kinds of goods sold in the Nelson store are those that you would see in any airport relay type store, which caters for travellers' immediate needs and are not the types of goods that the Act intended to be an appropriate complement to alcohol. It would not be complementary, for example, to items aged at those below the legal purchase age for alcohol, such as children's toys, which they may purchase to entertain themselves on the flight. It would not be an appropriate complement to the types of convenience items that you might purchase while waiting at the airport. For example, chips, lollies, snacks, newspapers, Panadol, or a forgotten toothbrush. In addition, it's important to note that being a locally produced product does not necessarily mean that it is a complementary product. And we have yet to hear a detailed inventory of the gifts and other souvenirs that may be sold within this shop to understand exactly which of those could in any way be considered to be complementary to alcohol and which indeed may not be. The nature of this store is such that it will likely be visited by unaccompanied minors. It's easy to think that within the context of the relative safety of an airport terminal, a mother might let her child go into the store to purchase some snacks on their own. If the store is granted an off-license, these unaccompanied minors have the potential to be exposed to alcohol advertising and promotions, for example, the tastings that have been originally proposed by the applicant, while in store to purchase their treats, books and toys. The applicant has not addressed in any of their testimony so far any barriers or physical controls within the store to reduce movement of minors into areas where alcohol will be for sale or to reduce their exposure to alcohol. And we've recently heard from the testimony from counsel for the applicant that this would primarily be reliant from point of sales and stopping the purchase of alcohol at that point, which we would suggest is really the lesser concern as opposed to the general normalization and exposure to alcohol that children may be exposed to within the store. Our concern is this.
I apologise for interrupting there. I'd just like it recorded that I haven't given testimony. I presume Dr. Gregg's referring to submissions from me. Thank you.
Correct. From the submissions from the applicant, you have heard that they have not addressed any physical barriers or controls within the shop, but indeed are reliant on the point of sale system stopping the purchase of alcohol by minors, which, as I've just stated, we would suggest is a lesser concern as opposed to the general exposure that minors may receive in the store. This may lead to the increase in alcohol-related harm, again, which is contrary to the object of the Act. The Section 36 prohibition on dairies and convenience stores. Due to the types of goods sold in the Nelson store, we also need to consider if this application for an ALF licence should be refused under Section 36, which overrides Section 35. The range of items offered in the Nelson store are designed to meet travellers and airport workers' needs for snacks, beverages, reading materials, and other items which it is convenient for them to purchase at the airport where no other stores are available. In this way, it functions as a shop of the kind commonly thought of as a convenience store, where a person can purchase a range of items that they may need in that context of being in the airport, especially food and beverages, and where they're far away from other larger stores. In this way, it operates similarly to convenience stores out in the community, which again provide a range of items and goods that are designed to meet the needs of their local community. We heard from the applicant that they consider their relay store offering, which comprises well over 66% or 2/3 of the Nelson store footprint, to be a convenience store for customers at the airport. They stated this model is categorised in their industry as a books, news and convenience stores. The absence of the sale of hot foods does not detract from the general sense that the items for sale in this store are consistent with what would be available in convenience stores. As the reporting agencies, we submit that the Nelson store is an airport convenience store, a store within the airport terminal for travellers and visitors to the airport to purchase their last minute items or grab something as they wait for the flight. The majority of items stocked are convenience items, including confectionery, snacks, beverages, and other essential items such as Panadol or a toothbrush. In summary, Section 35 states that the authority or committee concerned needs to be satisfied that this premise qualifies for an off licence. To qualify, the application must satisfy two conditions and not be overridden by Section 36. This application has not demonstrated that it achieves either of these qualifications and can also be overridden by Section 36. Neither does it satisfy the object of the Act to minimise alcohol-related harm. Therefore, our opinion is that the committee must refuse the application. Thanks, and I'd be happy to answer any questions.
Thank you, Alexandra. That's a very clear summary. I'm looking at the time, 45 minutes. Yeah, when I estimated yesterday, I think I was on mark.
I'd note that mine's probably been about 15 minutes.
Okay, I think it was a little bit longer than that. But anyway, we will not worry because I said that you all have a right to have a voice and be heard. I just know that voices take longer than we expect. Laurie and Derek, do you have any further questions? I have one subsequent question. I just want to clarify, so you raised in your, and at point number 13, you raised this price point of about $20. It might be a little bit higher than that, but nonetheless, you would be concerned by a 300% markup. I'm basing that on the fact that my mum happens to love the Kaharangi Sauvignon Blanc, which I know I can buy for her when she comes to town at probably between $12 and $16 at Raywood Fresh. So definitely I was feeling I was being quite generous by saying that it cost as much as $20. Perhaps a bottle of Newdorf Chardonnay might be more up at 20 to 30. But from a commercial point of view, I would find, in my naive knowledge, I'm a doctor, as I say, I would be surprised if most businesses could get up to a 300 or 400% markup on the cost of a bottle as opposed to a supermarket and be able to sell that. That's typically what you'd expect if you went to Hopgoods, that you might pay, $90 or $100 for a $40 bottle of wine. So I just don't see that as realistic. And I think the realistic thing would be that maybe they have 100% markup generously. So they're selling these bottles potentially more in the $30 to $40 range. So I'm just noting that I think this price point of $70 to $100 would most probably be on a very limited range of alcohol that would fall into that category, not, in my experience, the majority of Nelson wines, beers, ciders. Okay, and in terms of that, that $70 price point, I imagine it could be more spirits. You touched on it in paragraph 24, you touched on the normalisation of alcohol, which I guess is perhaps, I wanted you to expand a little bit because you are the medical health officer. I know you're representing all of the agencies, but on that normalisation of beer, wine, cider versus normalisation of spirits in terms of that visual, is there any concerns from Nelson Marlborough Health that we are beginning to normalise spirits increasingly into society, or are you fairly comfortable that alcohol is alcohol is alcohol?
Kate, I'm sorry, I'd have to object to that being asked of Dr. Gregg, who hasn't given any evidence in the proceedings at all. and that's inviting Dr. Gregg's evidence in relation to matters that haven't been
Okay,
introduced.
I'll retract. I just would like to
Committee.
understand what you mean by normalisation of alcohol.
Sure, and I'm happy to speak to that. And I don't think this is a court of law, so I wasn't quite aware that we could object. Otherwise, I might have made use of it myself.
I just record my objection again for the record as to this next part of the proceedings.
So what are you objecting to?
I'm objecting to asking a question around, in terms of a submission. In my view, you're asking for additional evidence,
Okay.
and that's not. It's not open.
I
to
feel
do
that
this.
Kate, in her questions to you, Nick, was also asking for additional evidence about the $70 to $100 price point, which had not been expanded on to the degree that you outlined. So if we're going to start going back and forth on who's providing additional evidence, I can think of several points in the hearing where you have introduced what I believe is evidence from your submission when, for example, you were cross-examining representatives of the reporting agency. So, if you want to go down that route, I'm happy to have that debate, but I'm also happy to just answer Kate's question on what my perspective as a person with 3 degrees in public health who's also working for their doctorate and has worked extensively in the health sector relating to alcohol related harm might consider the risks of normalisation for the committee's information.
So I'm going to just pause for a second. I'm going to take a 5-minute adjournment, but I do think, to be fair, this hearing started out with 3 agencies objecting outright on the grounds of the Act. So they hadn't, because they believe that Section 35 and Section 36 has not been met, their reasons for objecting was that this is not a legal application, okay, that we cannot approve it on the grounds of the Act. However, you have raised concerns about harm minimisation and how we minimise harm within the store if the application was approved. Now, keeping an open mind, I therefore have to turn my mind to, if the application was approved, what would the agencies, how would the agencies consider harm minimisation, and you were right to say they did not raise that much in their submissions because their submissions were primarily concerned with the words in the Act. Now, as Alexandra is here at the table and she is an expert on alcohol reduced harm and normalising alcohol within our society, I'm interested, because this has been the theme of the argument. A convenience store is not an appropriate place to have alcohol for sale. You've put forward an argument that it isn't a convenience store. Likewise, the agency have put forward an argument that it is a convenience store. The committee will determine, in our opinion, which way we go. We are keeping an open mind, but if we went one way, then we need to understand harm minimisation and the normalisation of alcohol in our society, because you've put forward a very compelling case that the Nelson brand includes the normalisation of alcohol. I want to unravel that a little bit.
I've heard what you've said, Kate. I still need to record my objection.
Okay.
The reason I say is because it's unfair and prejudicial to my client who has concluded the evidence. I cannot put any of the evidence that you are now inviting back to the witnesses for the applicant to give their comment about that. It is wrong to do this, and I object to it. And I'm grateful that you're going to adjourn to consider.
So I will consider
where
that,
to next.
but the questions have come up because you put forward a case that there was minimal harm from alcohol being for sale in the store.
And I have no difficulty with submissions, with answers to your questions in the nature of submissions from the medical officer, which is different and distinct from inviting the medical officer to give additional evidence commenting. But if
Would it be useful for me to provide a submission on the, I personally, I don't see the difference, Nick. The information will go to the committee regardless, but if it was to be in the form of a submission on the
I'm just
issue
going
of
to take a
normalisation.
5-minute adjournment, and I'm going to seek some advice from Michelle and Mark. Thank you. come live again. I'm going to attempt to reframe my question, and I'm trying to work very hard with you, Nick, to make sure that you also get a right of reply at the end of this. So turning my mind to your what was it called? What have we got here? What have we on? The bit, your submission yesterday plus your submission today. You highlighted to me ways the store was minimising harm and keen to minimise harm, and that you believe the store was addressing those issues of concern. I was wondering if Alexandra could respond to your submission, please, in terms of minimising harm and the normalisation of alcohol. How's that? Does that make sense?
So you would like me to respond to Nick's submission with my opinion as to what actions the applicant is taking and how they might minimise harm?
But also how
normalise.
harm minimisation, how that sits with normalisation of alcohol, because you mentioned that in your submission.
Sure. I hope I understand the question correctly. In terms of alcohol-related harm, we would suggest that some of the main alcohol-related harm comes from the conflation of the dairy convenience store type environment with an environment that sells alcohol. And our understanding of some of the drivers for the removal of dairies and other convenience stores from being able to sell alcohol is that they are premises that are typically occupied, visited by minors, and that they are not considered suitable environments where alcohol should be for sale, because it is normalising them. It's like if you went into McDonald's and with your Happy Meal you could get a beer, which you can in some countries, but we don't consider that appropriate in New Zealand because of the nature of those environments. They often are selling items which appeal to children, being visited by children, and they often are environments which are rife with advertising. They'll have advertising for Lotto, they'll have advertising for magazines, they'll have, in this case, we've heard of some of the branding that may be going throughout the store. And it is not considered appropriate that minors under the age of being able to make their own informed decision and being of an appropriate mental age and stage to make that decision in an informed way should be exposed to that level of promotion and branding. So for that reason, conflating the sale of alcohol and that kind of store that's attractive, open, freely available, freely moved around by minors does not meet, from our understanding, a approach that minimises harm, and in fact it normalises alcohol for young people. It's just, you can go in there, you can buy a candy bar and you can buy some beer, and that is not appropriate. Of course, in a separate store where entrance is more controlled, where it's generally not attractive to children and where they're not entering to buy chocolate bars or children's toys, that can more easily be controlled, and that kind of promotion, normalisation effect will be lessened. So that would be my comments. I think overall there is a harm that we've alluded to too, which is the proliferation of these kinds of stores, and that's something which I think all the agencies have alluded to throughout this, that we're really concerned about the precedent this sets for both Lagardère or similar operators to expand this operating into other airports, or indeed for competitors who are out there in our community to say, well, alcohol might be an interesting complement to my sales of books or other things within the local region. And again, there is a risk with that of normalising the sale of alcohol, making it a normal part of the activities that children might engage in. Imagine if you're going into Whitcoulls to buy some books for the school holidays, but alongside that is the display of alcohol, and mum and dad pick up some cider to take home. What kind of message is that sending? So that's really the concerns that I think the agencies have alluded to, and that we see really as underlying the very clear to us restrictions in the legislation that we have focused on throughout, that would guide us to say this is not an appropriate complement, and it is not appropriate because of the nature of the store, which we find is similar to a convenience store. Hope that answers your question.
That's actually very helpful. Thank you. Okay, so phew. I don't think Derek or Laurie had any further questions. And so now, Nick, we're going to hand back over to you for your right of reply. Where there will be no more questions, you get the last word. So, I'm not going to even mention the time.
Oh, that's okay. Look, I'll only be a few minutes in terms of what we've heard. The first point that I'd make is I think there is actually there is a degree of agreement, I would say, between the way you need to approach your task between the reporting agencies and us in terms of the legal framework and the 5 questions. I would say that actually in terms of what we've heard from the reporting agencies, they don't fundamentally oppose following that 5-question test. They just simply say to you that the factors, particularly in relation to questions 2, 3 and 4, should be applied differently by you. That's the first point that I'd make. And then the second point that I would make in reply is really just one about process and having regard to the evidence before you. When you think about risks of harm and indeed the risk of proliferation that is now raised, you just simply need to have regard to the evidence that's before you. And that was something that the authority had regard to again in the Gladding decision, where the authority was having to consider, and this was at page 35, where it stated there's no evidence that alcohol-related harm will increase, and it is unlikely given the limited hours and range of product proposed to be sold. You have to look at the evidence in this case. So with respect to Dr. Gregg, in terms of to the extent that she proposes now to include some comments around pricing, for example, of local wines, well, none of that actually is evidence. It was not put to any of the witnesses for the applicant, and she never asked any questions of Ms. McIntosh. So in terms of that being available to you, that is not evidence before you. In terms then, I guess, in relation to the steps, you've already had my submission, the steps that the applicant is prepared to take to minimise any potential harm from exposure to minors. And look, what I would say is that the way that these hearing processes play out, some things come into focus more than others. I would say just consider again in terms of evidence what was included in the initial letter of objection from the reporting agencies, and particularly the medical officer focusing only on section 35. You won't see the word proliferation there. And you won't see the word exposure there. You don't see the words harm to minors. So in terms of the way I would submit the applicant is constructively before you try to engage with those matters that have now been raised, and in my submission, there are appropriate controls that could be put in place to minimise those risks, promote the object of the Act and for this licensee to ensure the safe supply and consumption of alcohol from that sold at its premises. So look, thank you for the opportunity on those 2 points. Otherwise, you have my submissions. Thank you.
Thank you so much, Nick. We're going to close the hearing now. Yeah. Pardon? Yeah, we're going to finish with a karakia if everyone wants to stand. Oh, yes, I would like to have a site visit. So just before we do karakia, if we could all just sit, yes, I would like a site visit, please. I can do that just with you, Michelle. If Laurie and Derek, would you like a site visit? Yeah, okay. So yes, we'd like a site visit tomorrow. Oh, tomorrow, Michelle, you're away.
I can make a finish
Tomorrow or Friday, it's fine.
tomorrow. We can sort out the day.
We'll talk it. So yes, we will do a site visit. Just to confirm, we will do a site visit. I think that's very helpful in terms of getting a look and feel of the actual items for sale in the store. I think the photos show us the layout, but we need to see what's actually for sale in the store and perhaps look at how it's being used by the community as well.
Is it just the committee going on site?
Yeah. Okay, so I'm going to close the hearing now, and we're going to stand for a karakia. Tuia ki runga, tuia ki raro, tuia ki roto, tuia ki waho, tui te here tangata, ka ronga te pau, ka ronga te ao, humie, huie, tai kia. Kia ora, everyone. Thank you so much for your time and energy and knowledge. It's been a very interesting 2 days.